Civil asset forfeiture is a law enforcement tool. It's a judicial procedure for obtaining clear title to property that is derived from crime or used to commit crime.
There are a number of statutes, both at the federal and the state level, that authorize civil forfeiture.
There are two ways in which the government can recover property. You can recover it as part of the defendant's sentence in a criminal case. You convict the defendant of bank robbery and then you forfeit the proceeds of the bank robbery as part of the sentence. Or if there is no criminal case, then you can bring the action as a civil action.
Under criminal forfeiture, prosecutors have to actually prove there's a crime and prove that the property owner has knowledge of or consented to this criminal activity and the use of their property for this crime. In contrast, under civil forfeiture, there's no requirement that there's even a charge, much less a conviction against the property owner.
The government has to prove that a crime was occurred and that the property was derived from or used to commit that crime. So the government bears the burden on those two elements, and then the property owner who has intervened can attempt, if the government succeeds on those 2 points, they can attempt to show that he or she is an innocent owner.
The government only has a burden under the civil preponderance standard to show that the property itself is connected to a crime. But then, the burden shifts to property owners to affirmatively prove that they are innocent, to prove that they did not know about or consent to the illegal use of their property. And in this way, civil forfeiture turns the presumption of innocence on its head.
The system is not an undue burden on anyone. It is entirely fair. The property owner only has to send in a letter saying he wants to contest a forfeiture action, in which case it has to become a judicial proceeding in which the right to a jury trial applies.
Even the Department of Justice's own internal watchdog, the Office of Inspector General, has found that civil forfeiture undermines civil liberties and does not protect property owners.
Well, civil asset forfeiture is an essential law enforcement tool because it is not always possible to get a criminal conviction. Think of a case where the defendant has died. Someone like Kenneth Lay committed a fraud involving the Enron Corporation and could not be sentenced because he had died before sentencing. There are Russian organized crime elements that steal money in Russia and then invest the money in the United States in property. We have no jurisdiction over either the crime or the individuals, but the property is here, and we can use civil forfeiture to recover it.
Civil forfeiture has not just been used against the Walter Whites or the Tony Sopranos of the world. In fact, the majority of people that we see being affected by civil forfeiture are ordinary Americans who have had their property taken at roadside seizures, at airports, or in various other contexts. In fact, an in-depth study by the Washington Post revealed that from 2001 to 2014, across our nation's highways, law enforcement engaged in more than 62,000 roadside seizures and collected more than $2.5 billion without any criminal indictments or even warrants.
We often see in the newspaper that there's some criticism that the police stopped some guy driving his car and he was committing a traffic violation, and they seized the property and he had no recourse. And that's just false. He has all the recourse in the world. If it stays at the state level, he has recourse under state law. If it's adopted by the federal authorities, all he has to do is make a claim, and then the government has its burden of proof. But you need to be able to use civil forfeiture in cases of seizures of property from people at traffic stops, because those people are often couriers. You need civil forfeiture in cases where it's not clear who the wrongdoer is.
Because it's a civil proceeding, property owners do not have the right guaranteed to counsel or other protections guaranteed to criminal defendants. Additionally, one of the major problems with civil forfeiture is that it allows law enforcement to keep and retain forfeiture proceeds. These proceeds can be used for not only institutional benefits like paying for law enforcement equipment, but also for personal benefits under many different kinds of forfeiture laws. That includes salaries.
The overall point is that there is no reason to cut back on what is an essential law enforcement tool being used in a vast variety of cases that everyone agrees should be the focus of federal law enforcement just because there's a concern about how some state and local law enforcement agencies have used the money. You cannot enforce federal criminal law without it, because there are times when you simply can't do a federal criminal prosecution because of the defendant not being available or being unknown. He's a fugitive. He committed the crime overseas. He is overseas and he's resisting extradition. He has died. Or for all the other reasons that you have to do civil forfeiture because the property can be recovered but the crime cannot be proven in a criminal case.
No one in America should lose their property without being convicted of a crime. Law enforcement should not be able to benefit financially from the proceedings that they are responsible for, like the prosecutors who bring forfeiture proceedings. And property owners deserve heightened procedural protections. The only way in which to cure all of this is to eliminate civil forfeiture and replace it with criminal forfeiture.